This is Bloomberg Law with June Grasso from Bloomberg Radio.
It's a landmark ruling. Today, New Jersey became the first state where prosecutors can't build murder cases on medical diagnoses that the mere shaking of a baby caused a child's death unless there's further evidence of trauma. The New Jersey Supreme Court is the first in the country to block a shaken baby syndrome theory when investigations into child deaths don't show other injuries, such as bruising or neck damage. Joining me is Bloomberg Law senior correspondent Alex Ebert. Alex, tell us about today's decision.
This decision is a landmark opinion issued by the New Jersey Supreme Court that for the first time for a high court in the country says that you cannot bring a shaken baby determination from a medical perspective to charge someone with child assault, where if there's no external evidence of abuse, such as bruising or injuries on a child's neck, you can't bring the charges at all. And the reason why that is because there's big conflict in medical circles about whether or not these reliable symptoms that we thought for years were evidence of shaken baby syndrome child abuse could be caused by other means. And there's been new studies that show that perhaps these triad of symptoms, such as brain bleeding or bruising on the eyes, isn't actually enough to bring that evidence to court. The reason this is a huge landmark ruling is because we've seen bubbling up across the country different medical groups, biomechanical groups, and defense organizations saying we can, no longer ignore the conflict in evidence between what we thought was reliable in terms of child abuse and what is now questionable.
And this decision involves the cases of two fathers who were facing allegations of child abuse?
Yeah, the court was considering the cases of two fathers who both had premature children and were taking care of them, and they had seizure symptoms. These dads brought their kids to the hospital to get them looked after, and doctors determined, even though there were no external symptoms of abuse, such as bruising, that these fathers were responsible for injuring their own children by shaking them or slamming them. And the state public defender's office, ran to the judge and said, listen, we have these cases all across the country that are questioning whether or not you can bring this sort of determination from an expert in court.
In this 109-page ruling, did the court track the scientific evidence?
Yeah, the court went deep. So the majority of the New Jersey Supreme Court went through study after study going back to the 1960s, looking at how this diagnosis, shaken baby syndrome, originated. It went back to whiplash studies in cars using monkeys to determine exactly what happens to human beings when they're shaken. And it progressed through different studies by pediatricians and neurosurgeons up through the 90s when a large medical association for the United States said it's a presumption that if you have these symptoms that there's child abuse.
And where do the medical associations stand now?
The medical associations stand behind a diagnosis, which is what makes this complex. See, you have the industry saying we need to be able to diagnose these children and make sure that we can take them out of bad situations. But you now have a state Supreme Court saying just because you have this diagnosis isn't enough to rule out anything else. And that's not enough to come to court and say, based on my medical opinion, this is the only thing that could have happened.
There are 7 members of the New Jersey Supreme Court, and this was a 6-1 decision?
One of the justices issued a dissent here, siding with the medical organization, saying, listen, we can't be second-guessing the medical establishment here. We are not scientists. We are not people that investigate the scientific method. And she focused mostly on the medical associations that all backed up this diagnosis, where the majority focused on biomechanical experts who said, we originated a lot of the science behind how you determine whiplash and things like that. And if you don't have our consensus for this, then the consensus of the medical industry doesn't necessarily hold water.
Can this decision be appealed?
It would be difficult to appeal this decision. It would have to go to the United States Supreme Court because that is the only direct appeal from a state Supreme Court. There has not been a ruling on this to my knowledge, although there is some quotation of a Ginsburg dissent inside of the ruling today. This is now going to go back to the trial court, and these charges will be dismissed against these parents.
Is New Jersey different from other courts in the way it's been handling these cases?
Up to this point, there has never been a decision that goes this far, though you have courts start to become extremely skeptical of this no external evidence shaken baby syndrome theory. You've had, especially the Michigan Supreme Court, issue decisions saying, hey, we need to provide counsel that does a good job of contesting the state's evidence here at a deep level. And you've also seen criminal courts in Texas and the Texas legislature really question whether or not a death row inmate there should be in prison.
So up until this point, how would prosecutors construct a case against someone based on shaken baby syndrome? They needed some physical evidence, right? Or
they do. So doctors create this differential diagnosis by looking at, different markers on the child when they come in to get treatment. You look at things like bleeding on the brain or bleeding in the eyes and say, okay, something happened to this child that's more than just seizures, right? Or they look back at the child's past and say, did you have any accidental injury? Did Billy, fall down the stairs? And in cases where that's not present, they, think, okay, we're ruling out other things. It must be something else. But the problem there is the justices in New Jersey say, that's not enough to come to court and say, we've ruled out everything else. It can only be this.
So you need something else, something that physically shows?
That's right. You need something else. They call it external evidence, but it's some sort of physical, external issues with the body, right? Damage to someone's neck or bruising, other signs of abuse. And the dissent here calls out that this means that there could be parents or childcare providers or other people that get away with abusing children because there's just no external evidence of it. But on the other side, you have decades of people saying, we're putting away parents, and usually fathers, on perhaps flimsy evidence just because a doctor couldn't find a reason for it.
Are there a lot of shaken baby cases in this country?
I'm unaware of, reading through the briefs, how many there are, but we're looking at hundreds. There were several going on at the time when this decision was coming up in New Jersey alone.
So this is a forward-thinking decision, cutting edge. Is the New Jersey Supreme Court known for that?
The New Jersey Supreme Court is known for this sort of thing. It has extremely robust protections when it comes to privacy, and it's usually at the cutting edge of Fourth Amendment jurisprudence. We've talked in the past about how skeptical they are around, looking at things like someone's Google accounts and other subpoena information. But this falls in line with the court's skepticism towards allowing police and prosecutors to introduce evidence without it being questioned. Here you sort of see the justices line up in a way that we haven't in another court to say, in this instant where someone is saying it can only be this, we can't allow that sort of thing when there's not enough certainty in the field. We've seen decisions bubble up that look at client accountability for lawyers in this regard, right? But we haven't seen a court go this far. It'll be really interesting to see if other courts go as far as New Jersey and strip this tool away from prosecutors to tackle child abuse. Especially in our current climate where child abuse and the abuse of minors is a huge problem and concern. Potentially taking away that tool might be more politically sensitive in some parts of the country than others.
Tough balancing decisions, no doubt. Thanks so much, Alex. That's Bloomberg Law senior correspondent Alex Ebert. A handful of Fifth Circuit judges are mellowing out some rulings from one of the most conservative federal appellate courts. And they're the senior judges. Bloomberg Law's Jacqueline Thomsen has done some research on this. All right. So start by telling us about these decisions from the three-judge panels that are a little more moderate, less conservative than the full court's decisions usually are.
I mean, when we think about the U.S. Court of Appeals for the Fifth Circuit, we immediately think of a conservative appeals court. And, a lot of their rulings are very conservative, but there have been a few decisions lately that don't necessarily fit in with that pattern. For example, there was a 3-judge panel that said a Louisiana law that mandated the display of the 10 Commandments in public schools was unconstitutional. There was another one saying that the Texas A&M president at the time was wrong in canceling a student drag show on campus. And, those are rulings that we think of as not going in the conservative pattern that we think of when we think of the Fifth Circuit. So, I started to take a step back and look at who was actually on those panels. And for a lot of the Fifth Circuit argument panels, often it is a Trump appointee or more conservative member, a more moderate member of the court, and then a senior judge. And that's not always the case. Sometimes there'll be multiple Trump appointees. Sometimes there are panels with all Trump appointees. Sometimes it's all George W. Bush appointees. But, for these instances, that seemed to be the composition, either a Trump or Reagan appointee dissenting against a majority of the panel that was a moderate judge or a senior judge. And so I said, okay, well, what's the role that the senior judges are playing here? And, it just seemed to have more of an outsized impact than I expected.
Tell us about the composition of the Fifth Circuit itself.
Yeah, so I believe there are 17 active judges right now. And there are, on top of that, 7 senior judges who are still hearing cases. One other senior judge actually went fully inactive earlier this year. So that left just the 7. We have 6 Trump appointees on that court. We have 2 Biden appointees. We have, I believe, 2 Obama appointees, a couple of Clinton appointees, and then about 3 or 4 George W. Bush appointees acting as active judges. For the most part, one is a senior judge. We have 2 Reagan appointees who are active judges, and then we have other Reagan appointees who are senior judges. One senior judge who has been incredibly active is Carolyn Dining King. She is a Carter appointee. So, it really goes the whole spectrum of presidents who have appointed judges to the Fifth Circuit who are still hearing cases and who are still playing a really active role on this court. I mean, the Reagan judges are very active. I mean, 2 of them aren't taking senior status. Which would give Trump the opportunity to fill 2 seats on that court and sort of expand his wing. But, they're often in line with the Trump appointees on the court. So I can't speak to why they're not taking senior status, but that may be part of it, that, they're like, hey, look, I'm super relevant right now. I'm able to build up these majorities with other factions of the court right now.
So will you explain in general, because there are exceptions, as you note in your article, are the senior judges more moderate than the recent appointees, particularly the Trump appointees?
I think that's right. I think they're more moderate. They're more of an old school conservative. If you sort of want to put the Republican appointed judges in 2 factions, you might have, the active Reagan appointees and the current Trump appointees in one basket, and then senior judges who are also Republican appointees and folks who are like George W. Bush appointees in another basket. Sometimes there's some crossover there, especially on the fringes. There's one Trump appointee who might be more in line with the moderate wing, and then one Bush appointee who might be more in line with the Trump wing. But, for the most part, the senior judges, they've been around for a while. They've been appointed by presidents of a different generation, and they've spent decades sitting on this court. And, because of that, they may have more experience that makes them less willing to question settled precedent or to think, hey, maybe we should look at this a different way than we have been in the past.
And the Fifth Circuit has been sort of trying to test the envelope or move the case law to the right in many circumstances, and they've been getting reviewed by the Supreme Court a lot more than other circuits.
You're right that the Fifth Circuit does have an outsized number of cases that are going to the U.S. Supreme Court and that are regularly being considered by the justices. Some of that might be because these judges are writing dissents or concurring opinions that sort of say, hey, take a look at this case. I mean, Dobbs, which overturned Roe, that was a Fifth Circuit case. Jim Ho, a Trump appointee, wrote the opinion in that sort of laid the groundwork for the U.S. Supreme Court to take up that case. And, we see that in other instances, too. Judge Patrick Higginbotham, who was a Reagan appointee, he's a senior judge. He had written an opinion in a case involving Pornhub and Texas law on age verification requirements for, explicit adult websites that, some people say was sort of a way for the Supreme Court to take up that case because he said, hey, this is, what the precedent is on the books. And that allowed the justices to pick it up and then, alter or address that old precedent and say this is how it should be applied moving forward in upholding that Texas law.
Are the Democratic appointees on that court usually in dissent or not?
They can be in dissent. Sometimes they line up with the moderate judges. We see folks who are George W. Bush appointees like Leslie Southwick or Katarina Haynes. They will sometimes be lined up with the Democratic appointees who are folks like Stephen Higginson, Judge Graves comes to mind, Carl Stewart. Dana Douglas and Irma Ramirez are the two new Biden appointees. So they're all in the mix as well. And we do find that folks like Haynes, like Southwick, are more willing to reach agreement with their liberal colleagues than maybe other members of the court are.
And you mentioned a Clinton appointee who does a lot of dissents.
Yes, James Dennis. He is a senior member of the court. He only went senior a few years ago. And, he's been on the court for decades once again. And right now he's sort of viewed as one of the big dissenters on the court. And, one lawyer I spoke to who regularly looks at Fifth Circuit opinion says that seems to be a role that Judge Dennis sort of relishes because, it helps develop the law. Even if your dissent isn't the controlling opinion, maybe it raises the issue to the Supreme Court. Maybe it flags it to another circuit. As they're considering a case, it's still a way to be vocal, even if your point of view isn't the winning one.
Now, the cases that you mentioned in the beginning are headed to the en banc panel, so they could be reversed?
Yes. So when the Fifth Circuit takes up a case en banc, they actually vacate the lower panel opinion. So all those rulings have actually already been tossed out by virtue of the cases being reheard. So whatever the en banc court decides will be the holding opinion for all of those cases. And, it's interesting. The Fifth Circuit has a rule that if a senior judge was on the panel that heard the case in the first place, then they can sit on the en banc court alongside all the active judges, which are typically the members of that full panel. So it sort of changes the composition a little bit because you might think, oh, I have, 8 stalwart conservatives and they're going up against 6 to 8 other moderates or liberals, and, I'm going to have to focus on this judge or that judge to sort of win them over. But if you have a senior judge, then maybe that moderate pool expands a little bit more than you thought it would. And that sort of changes the calculus for lawyers who are arguing before the full Fifth Circuit.
To what do you attribute the spike in en banc cases?
A lot of them are hot button issues. I mean, we're talking about some of the really social, quote unquote, culture war topics that are coming up right now. The Fifth Circuit during the Biden administration was a hotbed of litigation. They've sort of lost that since so many cases are now going to the First Circuit or the Fourth or the DC Circuit. This is an opportunity for them to weigh in on these really important topics. Maybe as fewer of those cases are going through that circuit. I don't know this for a fact, but maybe there's more of an appetite for taking on those sorts of cases and being able to weigh in on those sorts of topics. And I mean, some of these judges are very vocal, so they're not scared to weigh in on these issues either. But, especially if there's old precedent on the court that they want to change, this is the opportunity for folks like the Trump appointees to do that. If that's happening in the First Amendment space, like in the Ten Commandments case, that's something that they'll be able to, shape moving forward. And then, if it goes up to the Supreme Court and they adopt that philosophy, well, then that's national precedent that they were able to have a role in playing and making sure that plays out that way.
You quoted from Senior Judge Edith Brown Clement in 2019 saying that Mississippi simply had the poor luck of drawing a majority-minority panel. in seeking a stay in a voting rights case. Is it stated or unstated that there is this political element where the Democratic appointees are more liberal and the Republican appointees are more conservative generally?
I think judges are sort of reluctant to put a label on like that, and I think some practicing lawyers before the court are at least publicly reluctant to do that sort of thing as well. So, I think folks like Edith Brown-Clement have no issue in putting that forward. I can't say that would apply to the rest of her colleagues.
Well, it would be nice if you couldn't identify politics in some of these decisions. Thanks so much, Jacqueline. That's Jacqueline Thomsen of Bloomberg Law. The Supreme Court has made it tougher on agencies with a decision that created a new legal test to determine when regulators have to bring cases in court rather than before in-house judges. So far, agencies are winning the battle, with federal courts siding with them in 34 out of 38 rulings. Joining me is constitutional law expert Harold Krent, a professor at the Chicago-Kent College of Law. Hal, start by explaining the Supreme Court limiting agencies and its ruling in the Jacqueline case.
So one of the ways that the Supreme Court has cut back on the power of administrative agencies is by directing, or at least allowing, companies to say that they belong in court, not before the agencies. And the court's done this in an unusual way by cutting back on something that used to be called the public rights doctrine, which said that if the government's involved, it need not go to court. It can instead proceed with a fine or a disbarment or a license revocation before an administrative agency and have the issue decided first there with appeal to the court thereafter. It's cheaper to go before the agency. It's more efficient. And yet the court has said that that's now in tension with its new understanding of the Seventh Amendment. And so the court directed in the Supreme Court decision called Jacqueline that no longer can the government rely upon these in-house agency administrative tribunals if, and this is where it gets tricky, if the action before the administrative tribunal resembles a common law action that was available at our nation's founding over 200 years ago. So it's a complicated, historical-based test, and then the courts have to pick and choose and decide, well, is this a fraud claim that looks like something in common law? Is this a fine for a privacy violation, which may not have existed in common law? And so it's going to take a while for the lower courts to sort through this to decide what kinds of government penalties can be heard before an administrative tribunal and what kind must go before a court, and because the Seventh Amendment attaches. That's slower, it's more ponderous, and so there's a lot of important stakes involved here.
So now a Bloomberg review found that by a wide margin, companies lost most of their initial attempts to stop agency in-house judges from hearing a wide range of disputes. Federal courts sided against the challengers, against the companies, in 34 of 38 rulings. Agencies also prevailed in 7 of 9 appeals court rulings. Why are these cases leading to these results? Are judges reluctant to pull the triggers, so to speak?
I think there's so many holes in the Supreme Court's decision that the lower court judges simply don't have a good playbook by which to decide whether or not the Seventh Amendment would attach. I mean, to give you a couple of examples, some major cases involve the Federal Communications Commission, which has issued huge fines against Verizon and against AT&T for compromising customer location data. And these are millions of dollars of fines. And so the court has to decide, well, is this obviously there was no customer location information available at the time of the founding. On the other hand, people not taking care of other people's, sort of property was well known at the time of the framing. And so what do? And 2 courts have held that the fines are okay, and 1 court has held that the fine is not okay. And so this case may end up going to the Supreme Court for clarification. Another case where there's a split was an interesting case. It had to do with the Department of Labor trying to protect immigrant workers or visas, making sure that their place of employment was healthy in terms of where they lived, in terms of bathroom breaks, in terms of food breaks, etc. And both cases were fines. And one court held that, well, this is just typical sort of fining a company for a violation of the conditions of employment. This looks like a common law action. And the other court said, no, this is unique. This is immigration. This is more tied to the public rights. And therefore, we're not going to say that there needs to be a Seventh Amendment for the employer here. So it's going to take a while for these cases to sift. The Supreme Court is going to have to get back into the fray because it is such a surprising decision. It reversed so many generations of cases and without many guidelines. And so the court's going to have to get back into the fray.
I mean, does this point out how cumbersome and at times inexplicable the test is to go back in history and see what the law was at the founding?
I mean, most people don't think the Supreme Court's test makes much sense. Now, the Seventh Amendment does have a kernel to it that the court has followed, which says that to determine whether normally a case should go before a jury trial does depend upon whether or not the cause of action resembles something that existed at the time the Seventh Amendment was ratified. So at least we have that test and we've looked at it. But the difficulty here is that these common law causes of action now are brought by the government in terms of fines and other penalties. So they're not like common law causes of action directly. And if there is the government involved, we've long thought that the Seventh Amendment doesn't apply. And so the court, by changing the rules of the game, has sown confusion, and it's going to take more cases for lower courts to understand what is the ambit of when these companies do deserve a jury trial before their claim fines can be adjudicated.
And some agencies can't bring cases in court?
Most agencies do have the power. It's just a matter of the time and expense. Jury trials take a long time. They're far more expensive. And plus, it would have a negative impact on the courts. The courts are not exactly ecstatic about having an increase in workload to hear these fines and other kinds of cases. So it's going to back up the workload in the courts as well.
And let's turn for a moment to the indictment of former FBI Director James Comey. In an opinion, a magistrate judge has already outlined 11 potential mistakes by the prosecution in that case, the prosecutor being newly appointed prosecutor Lindsay Halligan, the interim U.S. attorney for the Eastern District of Virginia, who had no prosecutorial experience at all when she went before the grand jury to get Comey indicted. And in court yesterday, she acknowledged that the full grand jury never reviewed the indictment that was actually filed against Comey.
So there was at the minimum, a clerical error that could be turned into such as procedural error that the entire case could be compromised because the grand jury actually voted on an indictment that it didn't see. Evidently, Lindsay Halligan cleaned up the first indictment because the grand jury rejected one of the claims that she had brought, and so changed the indictment and only showed it to the foreperson as opposed to the members of the grand jury themselves. So they actually, when they voted on an indictment, they did not see the actual legally perfect indictment that was at stake there. So we have a mismatch between what the grand jury voted on and what the indictment that is moving forward. Now, that may seem to listeners like a sort of a silly little mistake because the grand jury knew what was in the indictment. And it is. This pales, I think, before in terms of a mistake in comparison to the other mistakes that the magistrate uncovered just earlier in this week. But nonetheless, it's a legal error, and it's an error that may doom the indictment. And so she'd have to go back and seek another one because under federal law, there is a 6-month gap or you are allowed to seek an indictment if one unravels. And so that may be what happens, but there's other penalties that the judge may impose for the other mistakes, such as, obviously, if the judge finds that it's a vindictive prosecution, then the entire prosecution goes away and the indictment cannot be refiled.
One of the major errors she made was basically to say that Comey doesn't have a Fifth Amendment right not to testify, and that, the jurors could hold that against him, that he didn't testify at the grand jury. I mean, that's a huge mistake, isn't it?
Oh, it's a huge mistake. And then to also say that the grand jury could consider that the government will bring additional evidence at trial, again, makes a mockery of the whole grand jury system, because the grand jury, as a textbook matter, has to decide whether or not there's enough information presented to them to establish probable cause. And so, in that sense, mistake after mistake. And as I think that the court may say that as a penalty for all these mistakes and for the vindictive prosecution, that no further indictment can even be pursued. That's a possibility. It's a strong possibility, not for sure, but I feel pretty comfortable this indictment is going to be doomed.
Hal, everyone says statute of limitations, but you think that the law that allows a prosecutor to cure an indictment within 6 months, you think that would nullify the statute of limitations problems?
Yeah, it would if the court decides that this is a technical violation. And if it's a mere technical violation, like showing the wrong paper to the grand jury, then as a matter of course, I think the court would say you can remedy this by having a new indictment within 6 months without violating the statute of limitations. On the other hand, if this is because of bad behavior, and it certainly seems like it was bad behavior, then the penalty may be throwing out the indictment entirely, and the statute of limitations has run.
Thanks so much, Hal. That's Professor Harold Krent of the Chicago-Kent College of Law. And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcast. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.